The Punjab and Haryana High Court held that the Juvenile Justice Act 2015 would not apply in the cases of the inter-country adoptions of the children being given directly by the parents to relative known people under the Hindu Adoptions and the Maintenance Act 1956. The court also ruled out the requirements of the procuring the NOC from the Central Adoption Resource Authority for issuance of the passport to the child so adopted where the adoptive parents are Indians. CARA is a statutory authority established under Section 68 of the JJ Act 2015 governing adoptions among the special children, children in need of care and protections and children in conflict with law. Justice Nirmal Kaur was hearing a writ petitions where the passport authority had refused to issue a passport to the petitioners, a toddler girl given in adoption by her natural parents to her biological mother's real sister and her husband, NRIs, OCI card holder and citizens of the United Kingdom, for want of the NOC from the CARA. The petitioner's baby girl was given in adoption as per the Sikhs' rites and ceremonies performed at the Gurudwara, and a certificate to this effect was also issued. Pursuant to the adoption ceremony, the registered adoption deed was also executed between the natural and the adoptive parents of the petitioner. So the petitioner was duly adopted as per the Hindu Adoption and Maintenance Act 1956. Before the High Court, it was urged on behalf of the UIO states that it is a mandatory procedure for the adoption to be ratified by the CARA. The bench noted that in the present cases, there is no dispute that adoption has been taken by the person who are Sikhs and therefore have a right to adopt the petitioners under the HAMA, and even though they are British citizens, their religion remains the same and therefore their right to adopt under the HAMA cannot be taken away. Now we are joined by Advocate Divyanshi. So Divyanshi, can you please give us more updates on this?
Here in this case, the Honorable High Court has held that the provision of Juvenile Justice Act 2015 would not apply here.
Okay.
And a non-objection certificate that is issued from Central Adoption Resource Authority is not required if Hindu adoptive parents have adopted a child directly from biological parents of the child.
Okay.
The court has also mentioned a very important point here that in this case, though the adoptive parents are British citizens now, but their religion remains Hindu. So their right to adopt under Hindu Maintenance and Adoption Act cannot be taken away.
Okay.
And once adoption being registered under Section 15 of Hindu Adoption and Maintenance Act, it becomes irreversible and cannot be revoked.
Okay.